Hello, hello. It's Attorney Mike Graham coming to you from beautiful Rome. I threw up a little Rome background. Sorry, I had my alarm set at 6 o'clock in the morning here in Italy. Anyway, I woke up about an hour ago, and I've got a good SovCit from Alyssa, and then Zach also sent it to me. Thank you very much. So I'm sure it's made the rounds. I haven't seen it. I know it's got to be good. When I get it from those two independently, it's always good. So let's give it a look, shall we?
I will highlight for the court's attention that Mr. Leonard Blatt is present in the courtroom. I briefly conversed with Mr. Blatt, and he is confident in his desire and decision to move forward today without the assistance of counsel of my office. But just highlighting for the court's attention that he's present in the courtroom, Mr. Leonard Blatt.
Okay.
Always a bad idea. I might have to go find a fez somehow.
Is number 2 on the 2:30 calendar. Mr. Leonard Blatt, would you like to come forward?
I got a fridge here, so I don't have an ice bucket. Let me see. Oh no.
Sir, so are you Leonard Sabra Blatt?
Yes.
Okay, excellent. And did you have a chance, so you're here today for an arraignment, and the purpose, did you have a chance to speak with the public defender about your rights or what an arraignment means?
I declined to speak with him.
Okay.
Can I ask who you are?
Yes, so I am a pro tem judge. So I am pro tem Judge July Simpson, and I'm here. So I am the judge, the gentleman that was just here, Mr. Stashevsky. He was the public defender, and over here is Mr. Clark. He's the prosecutor representing the state.
Yesterday, I went to get the oaths of office and bonding information on all the judges of the court, but I didn't get yours because you weren't on the website as one of the judges. Do you have an oath of office on file?
So I am a pro tem or a part-time judge.
Mm-hmm.
And so there's a variety of those judges who work to fill in for the regular judges. I have taken an oath of office. I don't know what where they store those.
At the assessor's office.
So that's, I was sworn in by the chief judge, but do you have, are you prepared to go forward today?
I don't even know what
the hell is he talking about? God, they just make crap up always. I don't know that when you get sworn in, I don't think there's any document made or anything. It's just you get, there's a little ceremony and that's that.
But I haven't seen the criminal complaint.
Okay, are we able to assist with that?
I believe we can. If I send it to Madam Clerk, could we potentially get it printed out?
So what's our printer situation? Are we still? Oh, you are good to go. Oh, fantastic. Yeah, if you could print out Mr. Blatt's paperwork.
Actually, it's just a citation. I believe the court may have that on file. However, if you don't, I can once again just send it over. Yeah, I can send that over.
Well, what we're going to do is I'm going to get those printed out for you. Why don't you take a moment to look over them? The purpose of today is just to make sure that you understand the charges against you and the rights that you have, including your right to public counsel if you qualify for it. I would strongly urge you to speak with Mr. Stashevsky. He's here today and he can advise you of your rights. I'm I could advise you, but in case you have questions, that's your opportunity to speak with someone for purposes of today to better understand what we're doing here today.
I don't speak to the public defender because public defenders have advised me to perjure myself in court. And I suppose you've noticed I didn't stand when you came into the courtroom. It's nothing against you personally. I don't know you, but the U.S. Supreme Court has held.
Yeah, we didn't notice and we don't care.
That physical gestures are a form of speech, and standing is a sign of respect for the court. And I have no respect for.
This guy really reminds me of an older David Crosby. Half of you won't know what I'm talking about, and he makes just as much sense.
Washington courts. There's too much corruption, unprofessionalism, and arbitrary.
Too much corruption and unprofessionalism in government? You don't say. Oh my God, you've uncovered something we've never thought of before. Holy Toledo. What are we going to do now?
Behavior. So I don't speak with public defenders because they've advised me to perjure myself in that. In the state of Washington, if you're a man accused of anything by a woman, you're presumed guilty until proven guilty. Whereas in jurisdictions where they go by the rule of law, you're presumed innocent until proven guilty. And if you're falsely accused, for example, of domestic violence.
I agree with you. David Crosby's got an excuse, A, and B was at one time, pretty good and put out some good material. So it doesn't mean that he makes any sense, but you're like, okay, you have some patience for it. Like, just whatever. You politely ignore David Crosby.
If you actually committed the crime, you can bail out of court, and as long as you don't contact the other person, you won't go back to jail. But if you're falsely accused, I don't think I have the court's attention. If you're falsely accused, you cannot bail out because the court notifies your false accuser that you're released, and that gives her a blank check to have you arrested again. And every few weeks, the public defender comes to the jail cell and gives you the good news that you can be released as long as you perjure yourself that you committed the crime. All you have to do is sign the paper and a no contact order will be issued. And I told these people I can't certify under penalty of perjury that I committed the crime because I didn't. And the public defenders will tell you, yes, but I know you're not guilty, but all the guys get out this way. Just sign and you can go home.
I bet he's guilty. I don't know what the charges are, but I'm not a court, so I can start with the presumption of guilt. If I'm a juror, okay, fine, I'll go the other way. If I'm sitting on the bench, fine, I'll go the other way. But I'm sitting on my YouTube channel, and based upon your just generalized stupidity, I'm guessing you're guilty.
When you're trying to make a decision whether to plead guilty or not, you need to know how long you're going to stay in jail. But in the state of Washington, there's no longer a speedy trial right. In the court rules, now the courts can extend your stay in jail by 5 days at a time, indefinitely.
So, sir, what we're going to do at this point is I'll say for the record that we have some disagreements about the law. We have some agreements.
I have no disagreements about the law. I like the law. My problem is that the judges of the Washington courts don't obey the law.
So, sir, what I'm going to do is I'm going to give you a chance to review the documents before you. I'm going to take a break until there are some other matters ready, and that'll give you some time to review those documents, and then I'll come back onto the bench and we'll proceed from there.
Okay, I don't know if I'm recorded on the record as saying I have no problem with the law. I pay good money to the legislatures in Olympia to pass laws for my benefit.
You pay nothing. Give me a break. On the record, I'm good with the law as in my insane interpretation of it. Yeah, we'd all say that. As long as the law says whatever the hell I want it to, I'm good with it. Oh, okay.
Benefit. Problem is, judges, I'm not talking about you, I don't know you, but judges in the state of Washington are free to disobey the law and flout the law. And it's like an endemic culture of corruption in the state of Washington. It's not only in the courts, it's in the law enforcement. I used to work for the Seattle Police Department, specifically the SPOG, Seattle Police Officers Guild, which is the police union. And they had me going out every day picking up checks from businesses. And these businesses were paying money to have advertising space in a publication the police were supposed to be printing. But it was a fraud. It was white collar crime that the police were committing. And people were telling me, hey, I'm not going to pay you this year because the publication has never been published and I haven't seen it. So I would go back to headquarters and say, listen, I'm getting complaints from people that we're committing fraud, but we're the police. I keep telling them we're the police. We don't commit crimes. We fight crimes. Can I have a copy of the publication we're printing so I can show them? Well, look, we're out of copies. Well, can you tell me where they're distributed?
Ah, old crank, just blowing the lid off everything.
So I can pick them up and show them. Look, we pay you, right? We pay you to go pick up these checks, so why don't you just be quiet? Well, it's embarrassing when people accuse me of being part of a criminal activity. And so at this point, the police started leaving the phone booths, their panels, just surrounding me, threatening to beat me up if I told anyone.
I'm just going to take a moment. I want to express that to the extent that you've had negative interactions with our judicial system, that I am, personally appalled by that, and I and hope that that's not, the system that we are working under. I believe in our judicial system. Otherwise, I wouldn't.
Oh God! And then here we go. We've got a leftist Washington judge indulging this crap. It's not before the court. You don't know if any of it's true. Don't presume like he is to make him happy. It encourages them. There may or may not be truth to whatever he's saying. Who cares? It doesn't matter. It's not before you. My God.
Be here today. Again, the purpose of today is an arraignment to ensure that you understand the charges that have been brought against you. We went ahead and printed a copy off for you to review. You've declined to speak with the public defender. So at this point, I'm going to give you some time to review the documents that we've printed out for you. Make sure that you understand that. I'm going to take a break from the bench until there's some other matters ready, and then I'll come back and we'll take up some other matters, including yours.
Okay, and I need some information about your official bond.
No, you don't.
Where is it filed and in what amount?
So let's.
No, you don't. But Judge, you already deserve this. She seems like a nice person as usual. It reminds me of the judge in Colorado, Con. They all fall into this trap. You accept the premise of they're crazy to calm them down, and they bite you in the behind with it instantly. When are they going to learn? Just, sir, that is not before the court. You've been charged with something. Let's deal with that. I'm not here to deal with your life full of grievances.
Like I said, I'm going to take a break. Please go ahead and take a moment to review the documents, and then I'll come back and we'll readdress this matter.
Okay. I'm charged with driving with a suspended driver's license.
Sir, I'm going to take a break, and then when there are some other matters ready, I'm going to take your matter up again.
Guilty. Let's start right now. Let's go straight to sentencing. If we can throw a tasing into it, let's do it. If you're driving without a license, that means a police officer observed you driving a vehicle and then they pulled you over and you didn't have an effing license. I'm not there. Okay, we'd have to have the proofs, but I'm 99% sure right now that he is guilty. Now let's move along.
Including yours.
Okay.
Thank you. And there are some dismissals ready, but in the meanwhile, we can go ahead and retake up the matter of Mr. Leonard. Suppose I should ask Mr. Leonard Blatt, have you had sufficient time to review the documents?
I haven't.
You have not? Or would you like more
Stay on
time?
the record. I have not been served a criminal complaint, and Court Rule 2.1 requires a criminal complaint unless there's an exception. Has the prosecutor claimed any exception to the requirement of a criminal complaint?
Your Honor, the state will just note that that in the state of Washington, a law enforcement agency can indeed file a direct citation with the court, and the prosecution can go off of that.
That is correct, but Court Rule 2.1C, B, subsection B, requires that the citation be signed. And what I've been handed is a citation and notice that is unsigned.
So,
Also, it hasn't been timely filed with the court, so I move to dismiss.
motion is denied. These are matters they have been put on the record. They're matters that you can raise later. What we're here for today is an arraignment. So we're just going to go through the arraignment process, and then you can go through. And so what I'm going to do first is—
The prosecutor hasn't moved to to deny my motion. He hasn't responded. You're supposed to be neutral, right? It's supposed to be an adversarial process. And the prosecutor, we don't know what—
You're supposed to file a motion, not make it orally in court. Okay? So just know a few of the rules before you open your mouth.
his position is.
Well, let's go ahead and take the prosecutor's position. What is your position, Mr. Clark?
Yes, Your Honor, state will note that that there is a signature
Oh my God. I get it. She's going to deal with it right now. But again, accepting his premise.
is an e-signature with the officer's name and his badge number. So on those grounds, the state will will stand against the dismissal.
The court rule does not provide for an e-signature. It says signed.
If you would just give me one moment, I apologize again. I recognize this is the second time I've done this. I did just get notification that there was a message for me. So just take a moment and I will be right back with you. I'm gonna see what the message is.
Okay.
And we will retake up your matter.
All right.
Thank you, sir. All right.
All right, Jefferson County District Court is back in session. Seated.
All right. We are back on the record with the matter of Mr. Leonard Blatt.
And Your Honor,
Yes.
just for the record, the state will note that RCW 1.80.061 states that a record or signature may not be denied its legal effect or enforceability solely because it is an electronic form. The state will also note that Court Rule 2.1B1 states that whenever a person is arrested pursuant to the statute of violation, which is punishable as a misdemeanor or gross misdemeanor, the arresting officer may serve upon the person a citation and notice to appear in court. So on all of these motions, the state will ask that on all of these purposes, the state will ask that the motion be denied.
I need to see the statute and see the notations on it before I can respond to that.
Absolutely.
I'd like to note a motion hearing for that.
Are you kidding me? It's a statute. Look it up. She's not your attorney. And she says absolutely. It's not her obligation. It's the law. Go look it up.
So what we're going to do is we're not going to be hearing any motions today. I understand that you do have some motions. And what I'd like to invite you to do is to file those motions in writing with the court, serve a copy on the prosecutor, and then that'll be scheduled. Your motions will be scheduled for a motions calendar.
Okay, and I have an objection to the citation and complaint not being timely filed.
So that's another motion that you can file. So today, the sole purpose of today is that we're going to go through the arraignment process. So we're going to get you arraigned and we'll handle that. And then after that, you are welcome to file any motions that you would like in writing. Serve them on the prosecutor, and they will be heard on the motions calendar.
Okay, and the court rules state that any appearance waives any objection to the complaint or citation and notice. So I have to withdraw my appearance.
So what we'll do is does the state have a position on that before I state what?
I'm sorry, Your Honor, the position.
Denied. Next. What are you doing, Judge? It's you. You're charged with a crime. You don't get to withdraw an appearance. Period. End of statement.
On what, Your Honor?
So you indicated that
I can restate what I said. The court rules state that when somebody appears in court, that is construed as a waiver to any objections to the citation and complaint, a citation and notice or complaint. So I have to withdraw my appearance.
So what I propose is that we note your
No.
objection and to preserve it.
I propose no. There's no withdrawing of an appearance. We're proceeding with whatever we're doing. That's it.
For a future hearing and proceed forward with the arraignment unless you would like to, that would be my suggestion.
State would agree.
Are you comfortable with proceeding with the arraignment with your?
Can you
objection
repeat?
noted?
I'm sorry, I'm not sure I understood you. Could you repeat what you said?
Yeah, so why don't we note for the record your objection to preserve your objection? And one thing that I could do is I could also step off and make sure that that will preserve your objection for you to determine what we should do. My view is that we should move
which is number one, wrong.
forward with the arraignment, but I'm also willing to step off the bench and ensure that that right is preserved for you.
I'm sorry. So the two choices are proceed or you step.
We have an epidemic in this country. We have a bunch of kindergarten teachers who decided to become judges. And they got to go. They got to go. It's literally destroying the system. She's not a stupid woman. She's nice, but too nice. And you've got to be able to handle your courtroom. I just see too much of this. It's making me crazy.
Off the bench?
For a moment so that I can consult with another judge to determine.
I'm really big on accountability and responsibility for one's actions. That's why I require a signature. So at some point along the line, someone's responsible for accusing me. And I also think I have a right to a judge. Nothing personally against you, but I need
That's cute. You don't. You're wrong on all these things. Denied, denied, denied. Let's continue.
somebody who can be held accountable for their actions. And it's easier to hold a judge accountable than a pro tem because they have an official bond on file. I'm not sure if a magistrate or pro tem does.
So pro tems, there is an oath of office on file. Pro tems are not required to file bonds, but what I think
No, he insults you and you deserve it. You indulge this. Now you're in the mud puddle with this guy. You're in the mud puddle with this guy. You kept buying his absolutely insane premise on every dopey thing he did, and now he knows you're going to indulge everything. Just say no. It's that simple. Nancy Reagan was right here. Just say no. No, your motion's denied. It has no merit. Next.
I hear you're saying is that you do have a right to request an elected judge to come hear your case. And so I do have one available who can come and step on and handle this matter for you.
Okay. Yes, I also just would like to add that the reason that bond is so important is because sitting on a bench as a judge is a potentially hazardous activity, just like driving a motor vehicle is a potentially hazardous
Sir, I
activity,
appreciate your-
which requires the
your
driver to have
views.
insurance. The
I
bond is
appreciate your views,
equal.
sir.
What do you mean it's potentially hazardous activity? Is that a threat? There's really nothing hazardous about sitting on a bench listening to, well, you can lose your sanity. But other than that, it's not hazardous. I don't think you know what English words mean.
To insurance for a driver.
Yes. So at this point, what I understand you to be saying is that you are expressing your request for an elected judge to hear this matter, which is your right to do. And I'm going to step off the bench, and I will have an elected bench step on specifically for your matter, and we can get this proceeding on its way. Okay.
Oh,
Okay.
All right. Here we go.
All right.
okay. So if they have a right to object to a pro tem judge, and then they get another one, that may be in the code or whatever, then fine. Then do that. This ought to be fun. Hopefully, but we're in Washington. We'll get new
All
maybe.
right, Thurston County District. Seated. All right, Mr. Blatt. We are.
I'm going to move on to some other matters, and then once the other judge is available, we will retake up your matter.
I need to state something for the record. The prosecution has cited a statute that conflicts with the court rules. The court rules were promulgated by the Supreme Court justices
Probably not, but if you think so, bring a motion. Next.
in this state. The statute was promulgated by the legislature. So the court rules take precedent over statute.
So your
So that's I don't have to go to the law
your
library.
statement is noted, and sir, I'm going to ask you to sit down, and we'll recall your matter once a different judge is available.
All right, Thurston County District Court now in session. Judge Sam Meyer presiding.
You can be seated. So,
All the way from Thurston County, it's Sam, the man Meyer. He's going to take care of business now. I do like him. He's too soft sometimes too, but he's fun. And not always. So, sometimes he gets cranky. It takes a while to push him there, but sometimes he'll get cranky and hold the line.
I'm on here just to hear one case. So Leonard Blatt, which one is Leonard Blatt? Oh, you can come on up and take a seat. So Mr. Blatt, my computer is very slow, so give me a minute. She been having trouble with jobs up here? I have in my office. So, Mr. Blatt, you're here. on a few things. First thing, on cause number 5A0421962, you're charged with 1 count of failure to transfer title within 45 days, 1 count of driving with license suspended in the 3rd degree, 1 count of a trip permit violation, and then there's also a trailing infraction of operating a motor vehicle without insurance. Anytime anybody is charged with a crime, they have a number of rights. You have the right to be represented by an attorney. If you can't afford an attorney, I can appoint an attorney to represent you at little or no cost. You have the right to a trial by jury in the county where the crime is alleged to have committed. You have the right to hear and question witnesses called by the prosecution. You have the right to call your own witnesses on your own behalf, and I can require the attendance of your witnesses through the use of subpoena. You're presumed to be not guilty of the crime charge. You cannot be found guilty unless the prosecution proves the elements of the crime beyond a reasonable doubt, or unless you enter a plea of guilty. You have the right to remain silent. You're not required to testify against yourself. At the same time, you do have the right to testify if you choose to do so. And finally, if you take this matter to trial and are convicted, then you would have a right to appeal to Superior Court. Did you hear those rights?
Yes.
Do you have any questions about them?
No.
Okay. As I said at the outset there, you have the right to be have an attorney appointed to represent you. Do you wish to have court-appointed counsel? Are you going to hire an attorney, or you also have the right to represent yourself if you can do that? Do you have a?
I'm not sure at this point I need to hire counsel.
I'm sorry?
I'm not sure at this point I need an attorney.
Okay. And then do you want to, Mr. Shashevsky, he's there from the Office of Public Defense. I can appoint his office to represent you. It may or may not be him. Is that something you're interested in, or are you going to represent yourself for a period of time? You can always readdress this issue at some point in the future. I just need to know where you're headed today.
Well, as I said, I'm not sure at this point that I need an attorney.
Okay.
Oh, sweet Jesus. What?
Well, you have the right to one. Whether we can debate whether you actually need one. It's been my experience when people are charged with a crime, they generally benefit from having one. But if at this point, based on what you said, I won't appoint an attorney at this point. But if you wish to readdress that at some point, you can do that. In terms about whether you need one, I think it's a good idea to have one, but you were going to say something?
Yes, it's been my experience that attorneys in the state of Washington advise their clients to perjure themselves in court when they're charged with domestic violence. They tell
Okay, so hang on just a second. I'm going to stop you there for a second. This case does not involve domestic violence. This is a simple, just stop for a minute. Let me finish, please. And so, and I can't speak to your experience outside of this court. I don't want to get previous experiences you have with an attorney or not get in the way of what we're doing here now. It's just a simple yes or no question. You whether you want an attorney appointed to represent you or not. And if the answer to that's no, then we're going to proceed. And if the answer to that's yes, then I'll appoint your public defense, and then we'll go from there. Or you can hire someone. I tend to doubt that every attorney in the entire state if any, do what you say, but you can hire an attorney of your own choice if you wish to do that.
Well,
I'm sure you could find someone. So what do you get? But what I need to know right now, I don't want to get into a philosophical discussion about what attorneys do or don't do in, outside of this particular case. I just need to know whether or not you're interested in having an attorney appointed to represent you or not. And that's a yes. I'm asking you a yes or no question.
Well, let's just say that because of the conduct I've witnessed by attorneys, that I boycott them.
Okay, so I'm going to take that as a no, and so I won't appoint an attorney to represent you at this time. But at the same time, again, I'll tell you again, and you're probably going to get told a few times over the course of this case, you can readdress this issue if you wish to do that. Who's handling this for the state? Mr. Clark, is that you?
I am.
I'm going to swear you in. Could you raise your right hand, please?
Yes.
Do you swear to affirm the information testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
You can put your hand down. So what's going to happen here now is this is an arraignment. This is the initial court hearing where you advised of your rights, pleas of either guilty or not guilty. are entered. If a probable cause is established, then I can set conditions of release. I swore in the prosecutor because I'll take his sworn testimony, which can include hearsay and reports from others, to establish probable cause. If I'm satisfied that probable cause exists for the charge going forward, the charge will go forward. We'll set conditions of release. We'll set a court date. I'll give you a court date. And then that'll probably conclude the hearing here for today. So, Mr. You're going to say something?
Yes, I'm confused because he can be sworn in under penalty of perjury, but he's not a witness to anything.
He's not.
So,
But he's what he.
You're confused primarily because you're stupid. He just told you, for the purpose of a probable cause hearing, we've got different requirements than the evidentiary requirements for a regular trial. That's the law, but you don't know it. So let's go back to when you turned down an attorney.
He is for the purpose of setting conditions of release, and the case is not being tried right now. And so he's not a witness, but he's the representative from the prosecuting attorney's office. He's an officer of the court. This is more of an offer of proof to show what sort of evidence would be presented if this were to proceed to trial. And again, nothing's being proven here today. It's just I want to know, and what judges do when they're setting conditions of release, if probable cause exists, if an offer of proof could be made that probable cause exists for the charge going forward. And that's what I'm going to hear from him today. And so that when he's going to say that, that's, it's not going to be tried in front of me. Ultimately, if this case might eventually be tried in front of a jury, not me, but I'm just asking him to do this simply for the purpose of, again, whether I can be satisfied that probable cause exists for the charge going forward and for setting conditions of release and having the case move forward. So, Mr. Clark, go ahead.
Yes, Your Honor. On April 10th, 2025 at about 9 p.m., the officer stopped the defendant on Old Highway 99 for expired registration. At that time, the officer noted to have seen a Washington trip permit in the window that was dated November 21st, 2024. The defendant was ID'd via his Washington driver's license. A records check advised the defendant was suspended / revoked in the 3rd degree. And at that time, he spoke with the defendant, who stated that he had bought his car. He had bought it for his son, bought that car for his son and never transferred it to him, as he lived in Minneapolis. And that is all. Those are the facts, Your Honor.
Okay, and so you're seeking probable cause for the trip permit and the failure to transfer title. I see the DWLS in the 3rd and the trip permit.
Yes, Your Honor. All 3 charges.
And the failure to transfer title.
Yes, Your Honor.
So, Mr. Blatt, I will find that probable cause exists for the charge going forward. Doesn't mean the state's proved it beyond a reasonable doubt. They'll still have to do that at trial. A plea of not guilty will be entered on your behalf.
Objection.
Okay.
There's no plea of not guilty on the record. I've not entered a plea.
No, you haven't. I've entered one on your behalf, and by your objection, you've preserved that for appeal if you wish to do that. And a not guilty plea preserves all your rights to trial, all the rights that I laid out in that recitation I gave you at the beginning. But a plea of not guilty will be entered in your behalf. I'm doing that. Your objection,
Okay, so probable cause, B.
I've heard
I
you.
withdraw the plea of not guilty. It is stricken from the record. Please don't give me the bums rush. Let's do due process here instead of streamline.
Bums rush. Is it 1958? I love it.
The process. I have some objections to the initiation of the complaint because I haven't been served a criminal complaint. The court rules require it. 2.1 subsection C requires a criminal complaint be filed.
In courts of limited jurisdiction, in district court, complaints you can also be charged by citation by the charging officer, which has taken place in this case. That's how it got charged, with a citation. If you want a copy of that citation, we can certainly give it to you. You have it.
Yes.
So again, I'm not quite done yet. And so, And so, again, I'm satisfied that resolves that issue. If you have issue, and clearly you have, and I'm not trying to give you the bum's rush. I'm just trying to, I am trying to get through the hearing. If you have issues, if you want to object to, entering a plea, well, I can ask you, are you going to enter a plea at all? If you're not going to enter a plea, then again, I think that the law supports me entering a not guilty plea in your behalf, which does preserve all your rights. And and if you have issues, sometimes people attack these sorts of cases on constitutional grounds. They indicate that the licensing statutes are unconstitutional. You can do all that, but you've got to get all that stuff in writing and get it properly before the court in the form of a motion. But you can certainly do that. But the arraignment stage where we're at now is just as a preliminary stage, just it's kind of the kickoff, if you want to make a football analogy, and that's where we go from here.
Okay, I understand that, and I agree with that, but I require my public servants to obey the law because I've witnessed too much flouting of the law in Washington courts.
Okay.
So yes, I have.
The irony of this joker driving without a license, talking about people flaunting the law. It's unbelievable. I mean, again, it's a small charge, but don't indulge it. So far, Judge Meyer's doing a good job, I'd say. I really would.
Served a citation and notice, and that is sufficient to initiate a case. The problem is it's unsigned, and Court Rule 2.1 subsection B requires that it be signed. Now, before you came into the courtroom, prosecutor cited a statute saying that it can be electronically signed, but that conflicts with the court rules, and the court rules take precedent over statute because the court rules are promulgated by the state Supreme Court, whereas the statute's promulgated by some attorneys in the legislature.
I think there's.
Oh God, we need to go back to Schoolhouse Rock again.
Okay, well, like I say, you preserve that issue.
The issue should be decided now.
What's that? No, you need to file appropriate motion and note it up for hearing. Anything else you wish to discuss?
Yes, I have some concerns about whether I'll get a fair trial. As I understand, this is supposed to be an adversarial process. But I'm being accused by a police officer who works for the plaintiff. The prosecutor represents the plaintiff. The witness against me is the plaintiff.
Yes, and you represent yourself. There's the adversarial process, dummy. Oh my God.
The jury that's supposed to sit here is selected because of their demonstration.
There's no jury yet. There's no jury involved unless you file a jury demand.
Loyalty to the plaintiff by applying for a driver's license when I'm charged with not having a driver's license. So they're inherently biased to begin with. You yourself have a flag behind you that represents the plaintiff. The public defender is licensed to make a living in the plaintiff's courtroom at the pleasure of the plaintiff. I've been educated by the plaintiff, so how can I get a fair trial in a courtroom where everyone represents the plaintiff?
Well, I'm not going to do far of a deep dive into those things other than to say I don't agree with a lot of what you're saying in terms of who the plaintiff is and whether or not your ability to have a fair trial will be tainted by his job and what he's required to do, or his job and what he's required to do. But and again, I'm going to go back to if you think that by that token, I guess if you took that to its logical extreme, no one could ever get a fair trial. I mean, people could do whatever they want. And I could say, like on that, yeah. Well, hear me out for a second.
Yes, they all do that, and they fail to see. Of course, they know that they're just trying to get out of paying their fine or whatever. But the logical conclusion of that is you can't prosecute anybody. It's a free for all. Okay, we have anarchy, and they imagine in a world of anarchy, it's a 1960s Valhalla, and everyone's like cool to each other. No, you just get eaten alive by the nearest guy who's stronger and has better weapons. That's how it works. We've tried it. We've developed society for a reason. like if there were no rules or no government, you would be gone. Someone would plunk you over the head and take your stuff tomorrow, and nobody would help you. The end. That's how anarchy works. If you really want to try it, go ahead, but the rest of us don't.
In terms of, like, just as an example of driving while intoxicated, if I think we would all agree that that's a bad idea. And so hang on just a second, and it is illegal to do that, but if no one could ever get a fair trial because the police are involved, then people could just do anything they want, drive, drunk all they want, and then they don't have to worry about it because a case would get thrown out, because they can't get a fair trial because the police pulled them over. And that doesn't seem to me like to be a great system. But again, I'm going to go back to where, if you have objections, if you have a reason to believe that you can't get a fair trial, and you can convince a judge that that's the case, then you need to, again, put all that in writing, make a motion, and go forward.
Okay, and I want to make sure the court understands I'm not an anarchist, and I'm actually glad there's a process for keeping dangerous drivers off the road.
Mm-hmm.
Problem is, the courts have connected family court with traffic court, and there should be no connection. The family court has power to suspend people's driver's license, and there is no due process in those courts.
Yeah. It's really not a matter of the courts. It's the legislature that enacted those laws. Okay? And you can argue whether or not they're a good idea, but you can't argue that they're the law. They are the law. That's how this stuff works. It's not up to the judge. It's so basic.
Can I stop you for a second? And that is, this is a common misconception. The courts don't suspend license, right? The Department of Licensing does. The court gives information to the Department of Licensing to suspend the license. And so the legislature has decided that certain instances in family law, for example, not paying child support, and that's just one example that I can think of, that would suspend your license. So in the family court, if someone doesn't pay child support, they'll tell that to DOL, and then DOL was the one who suspends the license. So it's a misnomer, but hang on just a second. And so the family court's not doing that. The legislature decided that's a reason to suspend license. And then the family court's just providing the information to DOL. So if you want to be mad about someone about that, you could probably be mad about the legislature, about the legislature for passing that law. But it's not the court that's doing that. It's the legislature that created the law. The courts are providing the information. The Department of Licensing is doing what they're required to do as administrative agency and suspend the license. So how that happened, that all happened over in the state legislature. What we're here, but doesn't have anything to do with this, believe it or not. Now, here, you're discharged with, as I said, DWLS in the third, failure to transfer title, and a trip permit violation. There's also a no insurance ticket, which is about the most expensive thing. Pleas of not guilty have been entered, which you objected to, and which you can preserve that for appeal. Conditions of your continued release are, don't have any criminal law violations, don't drive without license or insurance, and make all your court dates. And I'm going to give you a court date here in a couple of minutes.
Well, I object to those conditions on the basis that the court is presuming that I'm not allowed to travel in my car.
No, I'm not presuming anything. I'm setting reasonable conditions of release based on the charge, and that's pretty much it.
You're presuming I need a license to travel.
Well, you do need a license to drive on the highway, yes, absolutely.
Okay, well, I have a real quandary here, because the court rules state that if I make an appearance, that's construed as a waiver to any objections to the criminal complaint or citation and notice.
I think you can make any objection. You can raise an objection to your citation notice anytime you want. And if you can, again, note up the motion, and again, put it in writing, supported by law, case law or statute. And if you can convince a judge, which does happen from time to time, there are defective information, there are defective citations, and you can certainly, I've seen cases overturned on appeal because they've gone through trial and then they have an ineffective or inappropriate information. It gets overturned on appeal. So you can certainly object to all that and brief all that up, and you might convince a judge. It's up to you as to whether you can convince a judge that that's worth throwing the case out. But for right now, I have found that probable cause exists for the case going forward. Those are the conditions of release, the least restrictive conditions of release that are present. I mean, I'm not going to set bail or anything like that. And that's what I expect you to comply with.
I need to state for the record that my plea as of this point is a demurrer. And I also like the clerk to note for the motion calendar, a motion hearing.
Okay, you need to, before you get we're going to give you a pretrial date here right now. All right, it's going to be out of maybe about 6 weeks. And then when you get a written motion together, get it in writing, then you can do that.
I'm serving to the prosecutor right now 3 motions. One is a demurrer. They're different titles.
Okay.
One is a demurrer, a demand for due process. The second one is a demand to dismiss. And the third one is a motion.
Okay, you can go ahead and give that to the prosecutor, file it up here, and we'll set this for a Monday morning motion hearing. Sure.
Okay, I'm handing a copy to the prosecutor right now.
No, actually, she's not the prosecutor.
I mean,
The prosecutor's over there.
the clerk?
She's the clerk.
Save my copy, but it's okay. And I'm handing a copy to the prosecutor.
16th of So we'll set a motion for June 16th. June 16th on Monday morning. That should be plenty of time for the prosecutor to respond. And
These are these stamps, would you like these back?
so do we have, make sure we get a copy. So we have, is there just one copy of everything? And we'll give you a notice of that hearing. Yeah. And then once you get that, you're free to go.
I need to state for the record that I was able to get a copy of your oath of office, but not your official bond.
I'm not required to post a bond. I've never posted a bond.
There's a statute, and I don't have it with me right now, but it says that all employees of the county.
There's some law that I'm making up, but I don't have it with me right now. Oh, okay. Well, go ahead and find it and file a motion. Hint, it doesn't exist.
Have to have official bond filed, so I'll bring that next time.
Okay. You know, I will say something here, Mr. Blatt. You know, I've been at this job since 2008, and I've never been requested to post a bond. I don't know that any of my colleagues here have. I'm not familiar with any of the judges in Washington have, which may lead to some conclusion, but and I don't know where you're getting your information, but you know, I'd be skeptical of a lot of what you receive.
Okay. Find the statute in the instant. I think the reason you might not know about it is because the state itself pays for your bond. They don't require you to pay for it.
Okay.
The reason it's important is because just as a driver has to have insurance because he potentially could get into an accident, a judge is also in a potentially hazardous occupation where people can get hurt. And that's what the bond is for.
I'm not sure what you mean by that.
It's analogous to a driver having driver's insurance.
I don't think that's
Analogous, moron. And no, what you're post a bond for what? Because he could get hurt? What good does that do anybody? What good does that? What are you saying this is like a life insurance policy? What the hell are you on about? Whatever it is, you're wrong. But if you've got some code provision, cite the damn thing. You can't pull in with I don't have it in front of me. Unless it's something that everybody agrees is the case. I've said that many times in court. It's like I don't have the site in front of me, but it's something that both the judge, myself, and opposing counsel agree exists.
true at all. What do you mean that I'm in a job where people could get hurt? What?
Of course. The only tool the state has at its disposal is violence or the threat of violence.
Are you threatening me?
No. The opposite is happening.
I need TP for bunghole.
The whole apparatus here is to threaten people. I mean, that's only two things.
See, and again, I'm gonna, I will say this. I just think that you're, and for what it's worth, I will try. But and you're operating, and I see you've been through this quite a lot over the years. And so, I think some of the assumptions you're operating under, may not be accurate. I'll just leave it at that.
Well, let me
And again,
ask you, how are you going to get people into a jail cell? You're going to lure them with candy? Are you going to have them bail, handle somebody that's unwanted touching? That's violence. I'm not criticizing you
I don't know. You look like candy might work.
for that. We want the state to have a monopoly on violence because sometimes it's needed.
But see, all right. Do you have a cell phone where we could send text reminders of court dates to?
I provided that already.
Okay, great. I didn't realize that. And so if we have it, then you'll get a text reminder of court dates. We'll see you back here on the 16th. I'm going to step off and then come in and finish the calendar.
All right.
Well, that was absolutely craptacular. I did enjoy that. We get the same tired arguments. Although this guy went full hippie, which is not, it's not all of them, but that's his thing. That always cracks me up. This notion that, we don't need any laws and everyone will behave. Well, wrong. We've had thousands of years of history where that wasn't the case and therefore created laws. They think they came up with it. like cavemen were rolling around just going, we're free and happy and everyone's like super excellent to each other. But let's create an annoying entity that takes some of our money and imposes rules upon us. No, that's not how it happened. How it happened is people weren't nice to each other and entire families would get wiped out on the daily. And then they said, we need some order. I mean, that's a shortened version, but that's basically what occurred. Okay, this goes over a long period of time, but people just completely oblivious to human nature and history. That's what we're dealing with here. There you go. I think all this because Jerkoff over here wants to drive without a license. I'm sorry, it's not the crime of the century, but you can't do that. There's a little punishment for it, and you're going to get it. The end. Thanks for coming out. Oh yeah, it's still early here. I'm about to go do some stuff. I went rolling around Rome yesterday. I looked at my phone because I was curious because I'd done so much. 25,000 steps. I wasn't looking. I wasn't trying. I wasn't doing it. That's what happens when you're over here. There's too much cool stuff to see. Good times. Yay, Rome. Thank y'all for coming out. I appreciate it. That's legitimate. That's legitimate background there from this trip. Sometimes I do that when I'm on the road because yesterday I had a bunch of people saying, "Hey, are back in the United States?" Because I have my Chicago backdrop up. I'm like, all right. I got to throw a different backdrop up for today. All right, thank you for coming out. I appreciate it. I will see you all soon.